Hello, I'm Mike Borslow, Executive Director of Massachusetts Youth Soccer Association. And welcome to a specialty webinar that's being recorded for your education is Liability and COVID-19. Now we know since our last live Q&A webinar that we have received quite a few questions, concerns, thoughts, ideas with regards to the topic of liability, and specifically what happens now that we know that our liability insurance will have a communicable disease exclusion. So what I'd like to do is I'd like to start right off and introduce our key presenter for this session, and that is David Amadon. David is the Executive Vice President of Mass Youth Soccer. He's been a longtime coach in our system, very, very involved in Newton Soccer, and then has been on the Mass Youth Soccer Board for close to, 10 years, I think. David is also a partner with the Boston law firm of Burns and Levinson. Of course, whenever you have a lawyer presenting, you have the caveats. So what I need to make sure is that everybody understands that the information contained in this communication may not be, may not be considered attorney advertising. Nothing in this communication is intended to provide legal or other advice or create an attorney-client relationship. With that being said, I think Dave has a few more caveats to share. We'll launch right in. David, it's all yours.
Thanks, Mike, and want to wish everybody a happy Labor Day weekend. Hope you're outside enjoying some of the nice weather we seem to be having. As Mike mentioned, in addition to my role as a board member and executive vice president of Mass Youth Soccer, my real job is being a partner in the Boston law firm Burns and Levinson. My firm's general counsel has asked me to make it clear to all of you at the outset of this webinar that I am not wearing my lawyer hat today. I am here strictly in my role as the EVP for Mass Youth Soccer. So here is my obligatory disclaimer. Nothing I am about to tell you is intended to be legal advice, and at the risk of stating the obvious, none of you should infer or assume that I am now your lawyer, because I am not. Before I begin my remarks and then the Q&A session that's going to follow with Mike, the one piece of advice I am able to give all of you is this. Please do not assume that the information presented today is all you need to know for your particular situation. After you leave today's presentation, I strongly suggest that you speak with your own and your organization's attorney who can advise you and your organization better about these issues. Okay, Mike, we can take the next slide. Okay, so the objectives for today, as Mike mentioned, are to understand the risk presented by the reality that COVID-based claims would now not be covered by our insurance, and offer you perhaps some tools to help mitigate that risk. So what exactly is the risk? Someone contracts COVID and alleges that it was because she participated in your soccer program, so she or her parents hire a lawyer and sue everyone for the resulting costs and damages. Now, typically, our liability insurance would step in to cover the named defendants. They would pay for the defense costs of the lawsuit, and they would indemnify or reimburse the defendants for any settlement amounts or damages that might have been assessed. However, and what brings us here today, is that most, if not all, liability insurance that's being written today has excluded from its coverage any claims related to infectious or communicable disease in humans. And this would, of course, include COVID-19. What this means is there is no coverage for either defense costs or indemnity. Now, while this is very much in the news today and in front of us as a challenge for our organization, It's not really new. The exclusions for communicable disease have existed for many years. They largely came about as a result of the MERS and SARS outbreaks several years ago. Carriers began to exclude coverage. You could buy an endorsement. That's now not available. So it's a full exclusion now. Okay, Mike, how about our next slide?
My slides froze, so just make sure I'm on the right slide for you.
All right, let me take a look here quickly.
Yep.
Yeah, that's good. Okay. So we're going to cover today understanding risk and maybe some mitigation tools around that risk in a couple of different groups of people. First would be what are the risks and what are the protections available for our member organizations and our affiliated leagues? And you may hear me refer to those as entity level protections. Second group would be directors, officers, and staff of our member organizations and affiliated leagues. And that would also, of course, include the state office. The third category, and perhaps the most important category, since they are among our most important constituents, would be protections for individuals who are volunteers, either at the state office or with our member organizations or affiliated leagues. Okay, are your slides still frozen, Mike? Are they? There we go. Okay, so let's start off with the entity level conversation. Massachusetts has a statute that's generally known as the Charitable Immunity Cap. The reference to the statute is on the screen in front of you. Basically, Section 85K, as I'll refer to this, provides that charities are entitled to a $20,000 limitation on liability for tort claims arising out of the course of their activities. All right, so let's unpack that a little bit and see what it actually means. So a tort is a legal wrong which one person or entity commits against another person or entity, and for which the usual remedy is an award of damages. Now, Section 85K applies to charities. There's no definition expressly of charities in the statute, so the courts have looked at several factors surrounding the organization's work, such as whether a dominant purpose of the work is for the public good, whether the work benefits a large and indefinite group of people, and whether the work is tied to and advances the charitable purpose of the organization. We're going to assume for purposes of our conversation today that Section 85K would apply to our member organizations and our affiliated leagues. Digress for 1 second here. We've been talking with a lot of you about reviewing, updating, and checking on your governance documents. This is a good opportunity to recommit to doing that and make sure that you understand what's involved in being a charitable organization, if you're a 501c3 corporation, for example, and make sure that you are operating as a charity. And so again, the protection here is that even if a claim is brought and it alleges huge amounts of damages, as long as you meet the definition of a charity and as long as you are operating, furthering your charitable purpose, your organization, your town organization, for example, is limited to $20,000 of liability in that regard. All right, Mike, how about the next slide, please? Let's talk a little bit about protections for one category of affiliated individuals, directors and officers and staff. Again, getting back to the governance piece, you really need to be sure your governance documents are up to snuff. One of the things that charitable corporations are permitted to do is provide indemnification for directors, officers, employees, and other agents of the corporation for the conduct of their activities in furthering the charitable purpose of the corporation, of the entity. I'm going to use an expression today a lot. It's called staying in your lane. And what I mean by that is a lot of these protections are going to be available as long as the activity or the actions or omissions that may become the basis of a claim arose in the ordinary course conduct taken in good faith to further the purpose of your town organization, of your club. So again, this is not about bad actors. This is about people acting in good faith and the protections that are available for them. Mass Youth Soccer has a current bylaw provision. You can find it on our website that deals with indemnification. Can illustrate for you a little bit about how that would work. Again, I urge you to, as a takeaway from this, call to action, review your governance documents, and make sure that they're up to snuff on this point. In addition, Massachusetts general law has a limitation on tort liability for officers and directors. We talked a minute ago about what torts are. Chapter 180, which is the section of the Massachusetts general laws that deals with nonprofit or charitable corporations, allows a director, officer of a corporation to be free from liability for the performance of his duties if he acts in compliance with the section of the law. So this really establishes a two-part test that, if satisfied, can provide insulation from liability for the performance of the director's or officer's duties. The first part is that the action is taken in good faith. And the second is that the director or officer has a reasonable belief that the action is in the best interest of the corporation. So again, staying in your lane, critically important piece. Massachusetts also has a statutory liability cap for uncompensated individuals who act on behalf of the corporation in furthering its work. It basically provides in relevant part that no person who serves without compensation, other than reimbursement for expenses, will be liable for any civil damages as a result of any acts or omissions relating solely to the performance of his duties as an officer, director, or trustee. Now, this provision would apply to the leadership of your organization. This does not extend to, say, volunteer coaches or team managers. This is limited to directors and officers. We'll get to the other volunteers in a minute. Okay. All right, Mike, why don't we flip to the next slide. So the third category of folks that we want to talk about are the volunteers. We've talked about how Massachusetts law has liability protections for the entities, for your town organization. We've talked about a couple of different ways that your governance documents can protect the individuals who help run your organization through indemnification provisions in your bylaws. And we've talked a little bit about the statutory liability limitations available for directors and officers who, in the exercise of their responsibilities, again, staying in their lane. So what do we do about the vast majority of people who make our soccer programs in Massachusetts run as well as they do? And that's the volunteer coaches, the volunteer administrators, registrars, whole category of people that comprise by far the largest category of worker bees in our organization. In 1997, the federal government passed the Volunteer Protection Act, or VPA. I'll refer to it as the VPA. And the VPA provides that a volunteer for a nonprofit or charitable organization may not be held personally liable for harm caused in the course of his or her work for the organization if certain criteria are met. The first is that the organization needs to meet the definition of a nonprofit organization. Under the statute, that's any organization that is allowed tax-exempt status as a nonprofit. For example, Massachusetts Youth Soccer is organized under Chapter 180 as a nonprofit corporation and has received 501c3 designation from the IRS as a nonprofit. So Mass Youth Soccer satisfies the definition for purposes of the federal statute. Each of you, each individual member organization and affiliated league should determine your own status as a nonprofit organization for purposes of whether the VPA provides the protections for your volunteers. Critically important as part of your governance housekeeping. The second criteria is that the individual needs to be a volunteer. And a volunteer is defined in the statute as a person who provides services to a nonprofit organization, but does not receive compensation or anything of value in excess of $500 per year for his or her services. There's a carve out from this for reasonable reimbursement or allowance for actual expenses that may be incurred. That would not count against the $500 cap. The statute only provides immunity to the volunteers, to the individuals. It does not provide immunity to the underlying nonprofit or charitable organization. So volunteers who are properly licensed, certified, or authorized, acting within the scope of their responsibilities at the time of the act or omission that gives rise to liability, and acting in a way that doesn't constitute anything worse than ordinary negligence, would trigger the statute, and the VPA would insulate that volunteer from liability. So, real world example. A coach organizes a training session for his team. He organizes it and conducts it in full compliance with Mass Youth Soccer's guidelines and with the state EEA directives and with the suggestions and guidelines put forth by the CDC and the WHO and every other acronym that you can think of. So basically the coach did the right thing, held the practice in compliance with everything. Someone on the team contracts COVID, and it is alleged that it was because of attendance at this practice or this training session. Everybody gets sued because everybody gets sued. The coach, as a volunteer, would have protection under the VPA because he was properly authorized to conduct the session by his member organization as a coach. In conducting the session, he was acting within the scope of his responsibilities as a coach, and his acts or omissions in conducting that in compliance with the applicable guidelines would almost certainly not rise above the level of ordinary negligence, even if it rose to that level. So that's the best example I can think of for the vast majority of our volunteers in terms of how the VPA might protect them. So again, you can see the importance of staying in your lane, because the VPA will not apply to willful or criminal misconduct, to gross negligence, to reckless misconduct, or a conscious, flagrant indifference to the rights and safety of the individuals who are harmed. Going back to our example, if the coach conducts a training session, doesn't follow the surface participant guidelines, doesn't require masks and social distancing, doesn't exclude obviously symptomatic participants from the session, those would probably start to rise to the level of misconduct that would exclude the coach from protections under the statute. There are a number of other things that are, again, kind of self-evident, I think, that would not apply, where the VPA would not apply: crimes of violence, terrorism, hate crimes, civil rights violations, actions committed under the influence of alcohol or drugs. Again, I put all of those things in the category of not staying in your lane. So just to sum up real quickly, I know I've thrown a lot of material out at you. I think that you can kind of parse through it and come up with a couple of different action items for each of you to take away from this. Number one, understand what the guidelines are that Mass Youth Soccer has put out. Inform yourself about the CDC's recommendations, the WHO's recommendations, the state's recommendations through the governor's EEA office. Make yourself educated, know what the right thing to do is, and stay in your lane. The second thing is review your governance documents. Make sure that they are up to date with risk management generally and in these areas in particular. Third, if you don't have someone on your organization's board or working with your organization who is an expert in these areas, as a lawyer, an insurance person, build those relationships, get the advice that you need to make sure that you have the full benefit of the protections that are out there and available. We may have lost our insurance coverage for COVID-related claims, but that doesn't mean that there are not things that we can do to reduce or even eliminate risk of significant economic loss and damage in trying to conduct programs to get kids on the soccer field, to get coaches out there coaching, and to continue the mission of Massachusetts Youth Soccer and our member organizations. Mike is going to have a few questions, I think. We'll kick
Yes,
that
David.
back and forth.
Yep. Actually, before I move on to the three questions, the most common, I'm staying on this slide for a reason: federal volunteer protection. Do you foresee any potential, and I'm throwing this at you, this is prepared, but federal legislation that could be addressed with regards to COVID-19 liability? In the past, we've had some catastrophes where the federal government has come in and said, this is something nobody ever expected. We're trying to get it under control. And so there's been some federal legislation passed. Do you foresee the potential for any of that taking place?
There have not been, and we've been looking at this for the past few months, generally. We have not seen a lot of COVID-based tort claims that have come out yet. In order to bring a claim in this area, it would need to be proved by the plaintiff that the person who is being sued, the defendant in the case, was what's called the proximate cause of the plaintiff or the plaintiff's kid contracting COVID. With the difficulties we have around contact tracing and isolating behaviors to find sources of the disease, that's a challenge. It's a real challenge to say that if, Susie came down with COVID, it was because she went to soccer practice last Tuesday afternoon, because Susie may have done a bunch of other things that could have exposed her. She could have gone to the store with her mom. She could have had a play date with friends. So, but that said, to answer your question, yes, I think that if there were to be a rise in the number of cases then it is entirely possible that the federal government could put in some liability caps or maybe liability exclusions, and limit or eliminate the ability to bring these kinds of lawsuits. That would be the kind of social engineering through legislation that the federal government has done. In other cases, they did it with asbestos. The Federal Tort Claims Act that came in many, many years ago drew some circles around what people could do, the plaintiff's bar could do around tort claims. So short answer is it's on the horizon, but it's largely going to be reactive. I don't think they're going to do anything before they see a big uptick in the number of cases that are brought.
Great, thank you.
Yeah.
Common question is, so what does this really mean to me, a coach who just wants to help out? I heard you say several times, let's stay in our lanes. And anything in addition to making sure that if I stay in my lane, anything, what could happen? I know you covered a lot of things. If you feel as if you've covered everything, great. But anything else to add to this?
Well, I would urge everybody to be as informed about the risks. Understand how this disease actually operates. There's a lot of misinformation out there. There's a lot of things that people are doing and not doing that may not be the best practices. If you educate yourself and follow the best practices as recommended by the public health officials, then that's certainly something I would urge everybody who's a volunteer coach to do. I would also suggest that you speak to your own insurance people. Most people, I would assume, have either homeowners insurance or some other liability insurance. They may have renter's insurance, that sort of thing. I would check with your insurance broker and find out whether your personal insurance would protect you from something like this. Most people know that if someone comes on your property and they trip down your steps, you have liability coverage to protect you for both defense costs and for indemnity. It might be worth checking. I suspect there's an exclusion in most homeowners policies and renters policies, but it would be worth checking. The last thing is urge your member organization to become knowledgeable about these risk management tools that we've talked about today. If you're a coach in a town, one of your takeaways from this should be to speak to your leadership team and make sure that they watch this webinar and that they start to look at some of the questions and some of the suggestions that we're making here about good risk management practices. So those are a couple things I'd suggest.
Super, thank you. So you kind of just touched on this about checking with my insurance carrier and making sure that I understand the guidelines. When it comes down to it, how concerned should I be about my personal risk exposure?
So we live in a society that is litigious. There is not a way that I've come up with in the 37, 38 years that I've been practicing law to prevent people from making claims against you if they feel they have claims. That's just not the way our system works. We have put in, at the state level, as part of our registration process, a release of liability and waiver that relates specifically to COVID-19 claims. And every child that registers through her parents and every adult that registers in the act of registering is giving this release and waiver of liability. Implicit in that release and waiver is a promise on the person's part not to sue the people who are being released. That is a defense that we have. It's not a surety that a lawsuit wouldn't be filed. But I think between the release and the lot of liability that we have and the other protections we've talked about today that are available to the folks who stay in their lane, as I say, I think the risk that liability would attach to one of these claims is relatively low. And I think that the cost of defending the case, since there's not insurance coverage for that, is probably the thing that would be the most concerning. But again, I think we haven't seen a lot of these cases, and a lot of times you'll see cases where there is insurance because there's a pot of money made available by the insurance companies to settle these cases. Plaintiffs' lawyers don't want to bring cases if there's not the prospect for a settlement where they can actually, make some money on this. And I don't know that there's a real consensus yet that this would be a fruitful area for litigation. So I think I still coach. I'm a volunteer coach. I coach in the Eastern Mass Women's Soccer League. I'm going to continue to coach. And obviously pay attention to what I'm supposed to be doing as a coach and make sure that my players are paying attention to what they're supposed to be doing as players, the parents, the spectators who come to the game. That's on me. That's my responsibility to make sure that everybody follows the rules and follows the guidelines. I think if you do that, I'm not that concerned about it at this point. It's a risk, but there's a lot of things that we do every day, all day long that represent some risk. And individuals will have different tolerances for this. Some people may decide that they just, it's just too scary and they may back off. I hope that's not the case because I don't really think it is the case.
Great. And lastly, we talked about this, and is there anything I can do to reduce exposure? I think I know what the answer is. It might have to do with
stay in your lane.
Right.
No, absolutely. I think it's a good question to kind of sum things up this morning, Mike. I think, and thanks for asking it. So again, I'll just tick them off for you. Educate yourself on the guidelines and the rules. Educate yourself about your organization, its status, what it provides. Understand the liability protections that you have as a volunteer or as part of the leadership team of your organization. And then spread the word. Be an ambassador for bringing the game back. And one of the ways we bring the game back is we get people comfortable in this new normal that we're in, that we can still have the game. It may not be the same game, but it's still the game. And getting kids out on the field, having them play, hugely helpful to them, hugely helpful to their parents, and I think ultimately be very satisfying for you as the volunteers and the folks that make Mass Youth Soccer run.
Great. Well, thank you very much. There's our contact information if anybody wants to submit follow-up questions or the such to myself or David. Again, we appreciate the many years that you've given back to the game and specifically to Mass Youth Soccer. It's we're fortunate to have the strong board that we do, and yourself and the others in leadership positions. So once again, I'll leave this up for a second so people can find us. It's rather easy. It's mborslow at MAU Soccer or EVP at mausoccer.org. So thank you again. We appreciate your time on a Sunday morning on a holiday weekend, but we know this content is important to get out there, and we want to let everybody know that Mass Youth Soccer is here to help everybody fulfill their roles, whether you're with a organization that is a nonprofit or charitable, or if you're with a club that is an LLC or C Corp or for-profit. There's a lot of protections that we have, and the biggest one to start with is ourselves. So if I walk away with anything, it's stay in my lane. So thank you very much, everybody, and we're here to help, and reach out if you need it.
Bye, everybody.